And do yours. Really, Vincent? Seriously, you just throw your case on the table?
Welcome back, everyone. Today's case drops us straight into a courtroom showdown that feels less like routine procedure and more like a collision of conflicting stories, missing evidence, and serious criminal charges hanging in the balance. On one side, we have accusations involving violent assault and deeply disturbing claims. On the other, a defense team aggressively challenging every detail, every piece of evidence, and every investigative step taken by police. Judge Simpson presides, and right from the start, you can feel tension in the air. This isn't just paperwork and procedure. This preliminary examination decides whether the accused even goes to trial on some of the most serious charges possible. That means everything said here matters. We're going to see officers questioned about their investigation, as evidence that may or may not exist, injuries examined, and arguments over whether the story told by the alleged victim holds up under scrutiny. And the defense? They're not holding back. They're going after inconsistencies, investigative gaps, and anything that creates reasonable doubt. And here's the twist. The biggest controversy in this hearing centers around something no one seems to have actually found. A so-called mysterious object tied to the most serious charge in the case. No physical recovery, no forensic confirmation, just testimony. And that's where things get explosive.
No, never mistake my courtroom for your home. Court calls the case of the people of the state of Michigan versus Michael O'Leary.
Michael Vincent on behalf of Michael O'Leary.
Wait, this is the date and almost time for the continuation of preliminary examination in this matter.
Absolutely. Just to confirm, we are on YouTube, correct? Thank you.
Sure. Yeah.
At the last hearing, the people said I do not have any additional witnesses. Deputy Corona is here.
Mr. Benson.
Yes, I'd like to call Deputy Corona to the stand.
Did he? Benson? I wasn't listening. All right. Sir, please come forward and be sworn.
Solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. See, state, spell your first and last name for the record, please.
Matthew Corona, Matthew
May I inquire?
Deputy, how long have you been a deputy?
On the road 5 years.
Prior to that, jail?
2 years. Approximately.
Okay. And you've, last 5 years, you worked the road,
Yes, sir.
taking calls.
Yes, sir.
On February 9th, it started at the 9th and went into the 10th. Is that fair?
I started at midnight, so. At
Okay. Did you take a call at that address?
sir.
Did you encounter a Jessica Kirkland?
Yes, sir.
And did she make several reports to you about a variety of incidents that she had with Michael O'Leary? Now I'm going to ask you about some of those. Were one of those incidents, and it's in the police report, page 11 of your report, if you want to refresh your memory.
Do you want me to move it up to a mic? Is that?
Well, maybe I just read it to them and if he agrees with. It says in your report, Michael punched her in the head several times, Michael O'Leary. Is that correct? You remember?
Here's where the prosecution is trying to establish the physical violence component, and it matters a lot. Multiple punches from someone described as a large man, over 6 feet tall and well over 200 pounds, is not minor force. In court, severity of force can affect how charges are framed and whether injuries are consistent with claims. But notice what the defense is already doing. They're not denying a confrontation occurred. Instead, they're laying groundwork to argue that the injuries seen later don't match what you'd expect from repeated blows by someone of that size. It's a subtle but powerful strategy. If the physical results don't match the story, then the story becomes questionable. In legal terms, this is about consistency between testimony and physical evidence. And prosecutors want a clear narrative. Assault leads to visible injuries. Defense wants doubt. If the injuries don't look severe, maybe events unfolded differently. And this becomes crucial later when photos are introduced showing injuries, because jurors will eventually ask, do these injuries look like what was described? So here's something to think about. If someone claims repeated punches, but injuries seem limited, does that automatically mean the claim is exaggerated? Or could adrenaline, movement, or defensive actions change how injuries appear? Keep that in mind. The injury debate is far from over.
Taking that report.
I remember typing that report, I can't say it was that set, that report in my report. Yes, sir.
I'm reading it verbatim to you.
Yep.
And would you agree with me that Michael O'Leary, is about 6 or well over 200 pounds?
Approximately, sure.
Okay. And Ms. Kirtland, more than one time told you that she was punched in the face, correct? Head in the face, okay. Did she say both head and face?
I don't know.
Okay. Have you seen people who got punched in the face during 5 years on the road?
I would say so, yes.
Have you seen people who got punched in the face by a man 6'4", approximately well over 200 pounds?
Actually,
Do they, assuming the punch lands squarely in the face, is it your experience that causes severe injury?
strong.
That's wrong.
I can't say it always happens or it doesn't always happen.
Does it happen? Sometimes so.
I'm sure it does, yeah.
And in your experience, have you seen people punched in the face by a large man several times? If you don't, can't recall, that's fine. Okay, all right. You heard a report that she was dragged or ended up near a stump on her property, which I think is, it's a kind of a half oval shaped driveway, gravel driveway. Do you remember that?
Yes, sir.
And there's a stump somewhere kind of towards the top of that oval near the house.
Somewhere on the property.
Do you remember her telling you that it was laying down there and something penetrated her that was cold? Do you remember? And do you remember her giving you any kind of detail about that?
Outside that it was cold, she wasn't part of my.
She ruled that out, correct? Now, did you ever look for that? You and Sergeant Thompson showed up there also, correct?
Yes, sir.
And there was one other deputy that arrived. As a matter of fact, the deputy who ended up arresting Michael O'Leary. Did anybody look for that, I'm going to call it, object?
I did not. I assume that other deputies did because I had an extensive conversation with Jessica.
Did you see anybody looking for that object?
I can't say that for sure.
Do you have any information that that object was recovered? If you did, it'd be in your police report, correct? So nobody told you that they recovered an object, because otherwise it would be in there. It's a pretty comprehensive report, and you'd put it in there. Do you know if a dog was called out to look for that object?
Now we reach one of the most critical pressure points in this entire hearing. The alleged object used in the assault was never found. No recovery, no forensic
She
testing,
ruled that out,
no
correct?
confirmation that it even existed
No.
beyond testimony.
Did you?
From a defense standpoint, this is gold.
Did you ever look for
Physical
that?
evidence is
You
king
and
in
Sergeant
court.
Thompson
If
showed
an
up there
object
also,
was
correct?
used, investigators usually
And there was
try to
one
locate
other
it,
deputy that
document the
arrived. As a
scene,
matter of
and
fact, the
collect
deputy
forensic proof.
ended up
Here, the
arresting
officer
Michael
admits he
O'Leary.
personally didn't search for it and doesn't know whether others did.
Did
The defense is
anybody
signaling
look for
something
that?
important to future
I'm going to
jurors.
call
If the claim was
object.
serious, why wasn't the
I did
scene
not.
locked down and searched thoroughly?
That other deputies
No
did,
K9
because I had
unit, no
an
spotlight
extensive
search, no
conversation
recovery
with Jessica.
documentation.
Did
But
you see
prosecutors
anybody
will
looking
counter
for
with
that object?
another reality. Crime scenes don't always yield
Do you,
perfect evidence.
do you have any
Especially
information
in
that
chaotic situations
object
involving
was
domestic
recovered?
disputes, late-night calls, and
If you
multiple
did, it'd be in
officers
your police
responding to
report,
urgent
correct?
safety concerns.
So nobody
So
told
the
you that
big
they
engagement question
recovered an
here,
object,
if
because
police failed to recover
otherwise
evidence,
it would
does
be in
that
there.
mean
This
the
is a pretty
event didn't
comprehensive
happen?
report,
Or
and
just
you
that the
put it in there.
investigation wasn't perfect?
Do you know if a
Because
dog was
trials
called
often
out to
hinge on
look
that
for that
difference.
object? Were you informed that Miss Kirtland was on her period or begun her period at that time? Okay, you were told that, okay. Now, did anybody, to your knowledge, go around that tree stump, walk around it anywhere and look for that object? You remember a conversation in the barn between you, Sergeant Thompson, and Miss Kirtland when Sergeant Thompson asked about going to the hospital?
I can't recall.
Do you remember her asking, do you need to go to the hospital? And Miss Kirtland said, no, I've had concussions before.
I can't recall that exact statement, but I'm sure I asked her at one point if she wanted to go.
And then do you remember Sergeant Thompson asking her, no, this would be for a for an examination that the hospital does for sexual assault?
I don't recall that specific question.
Do you remember her turning down that request? You don't remember that? You remember when you asked Ms. Kirtland, how did Michael O'Leary lose his front tooth? And she told you, I punched it, knocked it out?
Saying she punched him in the face, knocking his tooth out.
Okay. In your practice and training, is it usually the case that people who were sexually assaulted are requested to go to the hospital for a SANE examination? You know what a SANE examination is, correct? Which is a specialized nurse looks for signs of penetration of a woman's vagina. In your training experience, you recall that being the protocol? So it wouldn't be unusual for her to be asked to have a SANE examination. Do you know if she ever had a SANE examination? On your police report, I'll dial up the page. There's a section called Domestic Violence Supplement Report. Do you remember filling that out?
I did not know that.
You remember it being included in your report? Do you know who filled that form out?
Deputy.
Pardon me?
Deputy.
Did you have a chance to review it? You remember on there's like a breakdown of victim, suspect, relationships, medical treatment, things like that. You're familiar with the form, obviously. Now, on victim, it's checked alcohol. Would that mean, according to your training and experience, that means the victim had some type of alcohol in her system?
Such, yes.
Okay. Also, the word calm was checked. So do you remember that being checked for the victim? Okay. And down at the bottom, it says medical treatment is checked none. Do you remember that, seeing that?
Another subtle but powerful point emerges here. The report indicates no medical treatment was recorded. Defense attorneys love moments like this because jurors naturally wonder, if the injuries were serious, why no hospital visit? But context matters. Victims of violence don't always seek immediate medical care. Fear, shock, embarrassment, exhaustion, or simply wanting the ordeal to end can all influence decisions in the moment. The defense's strategy is becoming clear. Stack small doubts. No object recovered, no hospital exam, no immediate forensic confirmation. Each point alone may seem minor, but together they aim to weaken credibility. Meanwhile, prosecutors will argue that injuries and trauma don't always result in medical visits, and declining treatment doesn't invalidate what someone experienced. Here's something for viewers to consider. If you were shaken after a traumatic event, would you immediately want to go through hours of hospital examinations? Or would you just want to go home and be done with the night? This psychological element often becomes just as important as physical evidence in court.
There's talk about consumption of vodka out of a vodka bottle. Did you ever recover the vodka bottle? No. There's an accusation that the security system was messed up, tinkered with, destroyed, and so I don't know exactly, but ruined or wrecked that missed. Excuse me. Ms. Kirtland said that her security system had been destroyed by Michael O'Leary. Do you remember that? Was the security system ever recovered? You know if it was fingerprinted? Do you know that there was I forget exactly what you call them, those door cameras that record people going up to the door? Do you remember seeing that at the house? So nobody got a hold of a door cam, correct? To your knowledge? Okay. Now, there also was an accusation while Miss Kirtland was laying down by this tree stump that a motor vehicle came up to her so close that the bumper hit the tree, not her, hit the tree. Did anybody look around and take pictures of the tire tracks there?
I don't recall saying that a truck hit a tree, but I can also say I didn't look for tire tracks.
Nobody looked for tire tracks.
Not to my knowledge, I didn't.
Now, the weather conditions there, even though it was February, there was no snow on the ground, correct? And did anybody take pictures of the truck tire to see if there was grass on it?
I know I didn't.
Okay. Within the report, there were several mentions of her hair being pulled. The photographs that I've looked at, and I imagine you've looked at, shows Miss Kirtland with long hair. Did anybody collect any hair that was pulled out of her head?
I did not collect any loose hair.
Did you see any loose hair around?
I didn't observe any.
Did you look on the couch in the living room? Did you look in the truck? And nobody reported to you, I have a bunch of long brown hair. You're right, could I have a minute?
Yes.
So as far as you, there was no investigation on whether or not a large truck, there's a large truck we're talking about, correct? Yeah, pickup truck. Large wheels. If you remember, if you don't remember,
I can't recall.
No, it's okay.
That's also open to interpretation.
yeah. But as far as you know, there was no investigation of whether or not this large truck went off the gravel roadway onto grass in and around that stump we've been talking about. Okay. Thank you. Coming on your day off.
Really? Any questions?
Deputy, is this your report here? Your Honor, may I approach the witness with
You
this
may.
report? Thank you. Brought that up too because I'm going to direct you to a couple of specific pages. First, I want to talk about the lethality report, the form that's a standard form that Deputy Knott filled out. Mr. Vincent asked you about the box that is checked with the word alcohol. Do you recall that line of questioning? And Mr. Vincent asked you, does that mean that a victim had alcohol? And then I didn't write out the rest of the question. Do you recall that? And your answer was something along the lines of, I believe so. Do you recall that? When you answered that question, did you understand defense counsel to be, generally speaking, when that box is checked, does it mean that a victim has consumed alcohol? That's how you were answering that question in the general use.
Yes.
You were not answering that question to indicate that this particular victim had consumed alcohol or was exhibiting signs of intoxication.
That box being checked. During review.
Should not have been checked. Let's talk about the should not have been checked part. When you interacted with the victim, did you observe any signs of intoxication of her? Did you receive any evidence by viewing her or speaking to her that indicated to you that she was intoxicated by the use of alcohol? What about intoxicated by the use of any other substances? Thank you. Thank you for clarifying there. Turning your attention to page 9 of your report, and let me know when you're there. Mr. Vincent asked you a couple of questions. He asked you about the victim telling you that she had been punched in the head or the face, and you said you couldn't recall exactly what you said. Recall this line of questioning? I'm on page 9 of 19. I'm in the last paragraph. And if Your Honor, if I may approach the witness, I can.
Yes, you may.
Thank you. I apologize for my time up there, Your Honor. I'm
No,
on
it's
page
okay.
9 of my report, and I want to make sure Mr. Vincent
I'm
has
on
the
page
same
9.
copy as me. And he does.
9 is the same 9 on yours.
Yes, it's not the same 9 as Deputy Corona's, however. He's on a different 10. So, Deputy Corona, I have marked a little section there of where I'm at on our page 9 of your report. If you could read that out loud for us.
At which time Michael punched her in the head several times.
Thank you. That's taken from your section of your report where you are outlining what Jessica is telling you, correct?
Yes.
Thank you. I am going to turn to page 10 of my report. I'm still in the narrative of Jessica, so I'm going to come up, if Your Honor allows, to the witness
Yes.
stand. Thank you. You're on page 11, right?
Nope, I'm still on 10 now.
Perfect, thank you. So we're all on page 10, and I'm in the second to last paragraph.
Yeah.
And I'm going to start here. Thank you. Mr. Vincent asked you a line of questioning regarding the victim's statement to you about the penetration. Do you recall that line of questioning? I'm on page 10 of your report. I've outlined a specific section for us. Could you please read that into the record?
Michael pulled her shoes off and pulled her pants off and shoved something into her vagina. Jessica was unaware of what it was that was shoved into her, but described it as being cold and knew it was not part of Michael. Jessica confirmed the object.
Thank you. Just again to confirm, that is part of your narrative report of the information that Jessica provided you on scene. Thank you. Turning away from the report, you were asked a line of questioning about whether or not you searched the scene for an object that could have been used to penetrate Jessica. Do you recall that line of questioning? Fair to say there are a few other officers on scene with you. Sergeant Thompson, Deputy Knott, Deputy Lowe was not on scene. Was he in the hospital?
He
Or sorry,
went to the scene the night or the day after.
day after. Thank you. Thank you. So he was on scene, just not that night.
Yes.
Thank you for clarifying for me. My apologies on that. You don't know whether Sergeant Thompson or Deputy Knott looked for an object that night. You don't know whether Deputy Lowe looked for an object the next day. Thank you. You were asked a line of questioning about whether you found, I'm going to use the word clumps of Jessica's hair on scene. Do you recall that line of questioning? At any point, did Jessica tell you that the defendant pulled her hair out of her head? If I were to tell you that I reviewed your report, and fair to say that nowhere in your report does it say that she said he pulled her hair out of her head. Thank you. Your Honor, if I may approach the witness with People's Proposed Exhibits 1 through 4, I have already provided these to defense counsel.
Okay.
Yes.
Is there a stipulation to admission? Or do you want me to lay the foundation?
Yes.
Thank you.
1 through 4 are admitted for
Thank
exam.
you. And I apologize, Your Honor, I'm purposely not using the screens because we're on YouTube and the sensitive nature of these photos. Deputy, turning your attention to Exhibit 1, could you please describe for the court what we're looking at here?
That'd be a picture of Jessica's face. She has some markings to her face as well as her neck and upper chest area.
Now, when you say markings, if I were to use the word injuries, would that be an appropriate word as well?
Now we finally see physical documentation, photographs showing injuries. This is where courtroom narratives start colliding with visual reality. The officer describes redness, blood, swelling, and marks on multiple parts of the body. Prosecutors are reinforcing there was violence, and here's proof. But the defense will soon argue these injuries don't match what repeated punches from a large man would typically cause. They'll say you'd expect broken bones, severe swelling, or major facial trauma. This is where jurors often struggle. Injuries vary wildly depending on angle, force, defensive movement, and timing. Photos taken later may not capture initial swelling or bruising, and both sides will try to control how jurors interpret these images. Prosecutors, evidence of assault. Defense, evidence of a lesser struggle or mutual fight. An engagement question for you. When you see injury photos, do you instinctively assume guilt? Or do you still question how those injuries happened? Because perception often decides cases long before verdicts are read.
Do you see any type of redness anywhere?
Yes.
Where do you see redness?
On her neck and just above her, the line of her t-shirt.
And what am I seeing here on her nose?
I don't know if that's dirt or blood.
Thank you.
Some type of a foreign object, not skin.
Thank you. Turning your attention to People's Exhibit 2. What are we looking at here?
Jessica, right forearm.
And how about her elbow? Do you see that in the photo as well? What's noteworthy here?
There's redness to her elbow.
Thank you. Turning your attention to Exhibit 3. What are we looking at here?
Jessica's left leg and knee.
And what is noteworthy here?
Say redness to her knee.
And turning your attention to Exhibit 4. What are we looking at here?
Once again, Jessica's face, the inside of her upper lip.
Could you describe what we're looking at here on the inside of her upper lip?
It looks like a large blood blister.
Your Honor, may I approach and present those photos to Your Honor?
Yes,
Thank you.
thank you.
Your Honor, I have no further questions for this witness.
Any redirect, Mr. Benson?
We here earlier when Ms. Kirtland ruled out anything about Michael O'Leary as far as this mysterious or what, I don't know what to call it, objects you talked about that penetrated her. Were you here for that? Just about, I think a week ago, about a week ago. Okay. Now I've got the same bunch of photos. And you've been asked to look at some of the pages. My copy's all marked up. I refer you to the prosecutor's page 10 of 19. Do you have the report in front of you? Could you look at the first paragraph on top of page 10?
I believe my page 10 is different than your page 10.
Well, I'm looking at the bottom left-hand corner.
Yeah,
It says page 10 of 19.
yes, but earlier when I was asked the question, my 10 was different than.
I understand. I'm asking on this page 10 of 19. Do you have that?
I do.
I'm going to refer you to the top paragraph.
No, he doesn't have that. He can have mine though. I have 2 copies. Let me just get.
We have mysterious, besides mysterious objects, we have mysterious police reports.
Mine also has markings, so you know, but he can have my copy.
I can just read it to them to save everybody some trouble. It says, not the first paragraph, sorry, the middle paragraph. And I'll read it.
Okay.
Michael was still hitting her in the face. Do you see that?
You can see that. I have the same report as him.
Right here. You need my glasses?
No, I see now. I
Okay.
see. Oh, you're not at the beginning. You're at the end of a sentence. Okay. Can I approach and get him on the same? Can I?
Hey, sure. Anything that would help get everybody on the same page as Michael Vincent.
I will admit, it's kind of hard to read it,
No,
but I can read.
we
it.
were all just breathlessly waiting
I'm
for you to
open
start
here.
reading.
Okay, we're on the same page.
We're all, everybody on the same page.
All right, we are?
Again,
Okay.
Michael was still hitting her in the face. That was understood, I think. That means it was more than one punch because he was still hitting her face. It was still going on.
This is the defense swinging hard. The attorney uses personal experience, boxing, policing, to argue that punches from someone this size should cause much more damage. This tactic is powerful psychologically. He's inviting everyone in the courtroom to visualize what such blows look like in real life. But prosecutors would counter, not every punch lands cleanly. Victims move, block, twist, fall, or partially absorb blows. Plus, injuries can worsen hours later. What's fascinating here is how courtroom battles often become battles of common sense versus forensic nuance. One side appeals to lived experience, the other to medical and investigative possibilities. So here's a viewer question. Do you trust professional experience when evaluating violence claims, or do you rely strictly on documented evidence? And this clash between intuition and documentation is exactly what juries wrestle with.
You agree with me?
Make that assumption, yes.
Well, I'm reading what you put in there. And I've looked at these photos. You have them in front of you. I have probably more experience than anybody in this courtroom about getting hit in the face or hitting somebody in the face.
Yeah, that's probably true.
Thank you. And I'll be blunt with you. I mean, I used to box. I was a street cop for years, and I've seen a lot of people his size and even smaller. Stand up there, Mr. O'Leary, so everybody can see how big you are. All right, you can sit down. Somebody his size, I have a grandson who's his size who boxes. You hit somebody in the face, they mess the face up. They'll break a nose, break an orbit, close an eye, the face will be marked up. Not a scratch here or there. And there's no sign of that in the pictures. Do you agree with me? The pictures you took, the description I just gave, is that in any of the pictures you looked at?
I can't see bones in the pictures.
Granted, but you can see those eye closed. You can see nose bleeding. You can see swelling after you get hit in the face. It's a big, powerful man.
Not at the exact time those pictures were taken, no.
So you didn't see anything like that. When the pictures were taken,
Shut, I did not see it going up.
that's my question. Thank you. Remarked about her neck. This picture, you got it in front of you. In the police report and in earlier testimony, Ms. Kirtland testified that she was pulled out of this truck. Apparently there was 2 or 3 incursions in the truck where they were fighting with each other. You remember her telling you that? That she got in the truck to prevent him from leaving. And then 2 of them fought inside the truck. She got pulled out of the truck. And she testified she got pulled out by her neck. Now, and you're familiar with the phrase where the head goes, the body goes, right? The marks on her neck, you don't know where they came from, do you? They could have come from being pulled out by her neck out of the truck.
I suppose, but I don't remember her saying that she was pulled by her neck. I have to look at my report with that exact statement.
It's earlier testimony. If somebody, let's put it hypothetically, just to not put you on the spot about that. Hypothetically, if somebody's pulled out by their neck, particularly a fair-skinned woman, it's going to leave some marks on her neck. Would you agree with that? Thank you. Were you in charge of the scene, or was Sergeant Thompson in charge of the scene once she arrived?
I was the officer in charge.
Okay. So she wasn't actually in, she was there for a supervision or assisting you. Is that fair?
That's an odd question. I was the officer in charge.
I'm just trying to find out what her role was. I don't mean to interrupt you, but what was her role when she arrived there?
She assisted in the investigation.
Okay.
She's also a sergeant.
I understand fully. So do you remember her directing you or anybody else to look around that tree stump for this object? Do you know if she directed anybody? Did you ever hear her say, scour that area for this object? All right, thank you.
Are you done?
Sort of.
Other questions? Thank you.
Yeah, all right. Sir, you may step down. Go back to your day off. Oh, thank you.
Thank you.
We can release him, right? He needs to leave.
Okay.
We can release him. He needs to leave.
So,
He can leave.
thank you.
Yes, he's released. Yes.
Thanks.
Do you have any other witnesses?
Nope.
Any rebuttal witnesses or the people?
Your Honor.
All right, motion.
Thank you, Your Honor. At this time, we're going to motion to bind over the information. However, in the interim, we received the defendant's blood results. I am going to be adding misdemeanor count 8 high BAC. I have provided the additional discovery to that effect to defense counsel, so my office will issue an amended information. However,
With an added count 9 of high BAC.
yes, I apologize. I think I said 8. Yes, added count 9 of high BAC.
Could I inquire if the blood test came back 17 or above?
Oh, I apologize.
Well, it would if it's a high BAC.
No, I apologize. It's a 0.169. I apologize. Thank you.
Is 169?
Yeah, it's the 167. So
167.
I have the 7 and 6.
So it can't be.
Thank you. It's an OWI. Thank you.
Thank you.
Thank you.
Okay. Well, that's all you had to say.
One and only
Don't
time.
look so smug like you did something.
In terms of the motion, thank you, Your Honor. The people will motion to bind over on all of the felonies as written. Thank you.
Your Honor heard the testimony last week and about this mysterious object. My recollection is reviewing the testimony from last week. She never connected this object to Michael O'Leary.
Now the judge steps in and things get serious. Judge Simpson openly questions whether the mysterious object claim is credible, pointing out the lack of search efforts and missing physical evidence. This is rare courtroom candor. Judges usually avoid strong statements mid-hearing, but here we see real skepticism. The defense is thrilled. Credibility concerns from the bench help their case. But prosecutors push back, arguing credibility decisions belong to jurors, not the judge at this stage. And this matters legally. Preliminary hearings don't determine guilt. They only decide whether enough evidence exists to move forward. So even if the judge personally doubts parts of the story, the threshold to proceed is much lower than proving guilt beyond reasonable doubt. Here's the engagement question. Should a case move forward when evidence feels incomplete, or should charges be dismissed until proof is stronger? That question defines many courtroom battles.
We don't know what the object is. We don't know if this type of object exists. We don't know if Kirkland ever had any kind of physical evidence because she refused to go for a saying test. I have been doing this for a long time. This is not a CSC. I don't know what it is. It's not a CSC. No effort was made to look for that. The only thing I can put together on that is that they didn't buy this mysterious object any more than I'm buying it. No effort was made, no dog was called, no put a spotlight on the scene, nothing was done. Nobody even looked for it, let alone did a comprehensive search for it. It's clear that testimony, there was a fight between the two of them, at least 2 to 3 times. Great bodily harm. The girl driving charge of there. So I'm going to object to the bind over on the CSC. I understand the rest is a question for a jury. Who started the fight? How long ago? Was it really great bodily harm? Those are issues for a jury, but just simply not enough to bind over. There is no proof anything happened to this woman.
Other than her testimony.
Other than her testimony, granted.
Okay.
And I think the testimony is far from credible. She said, this happened. She can't describe anything except it was cold. And she clearly ruled him out. One of the last questions I asked her, We're ruling him out, right? Yes, she agreed with me. Ruling him out. If it's not him, it's not his body in her,
Oh, okay.
okay? Rules him out.
Right, but that doesn't mean that it wasn't a CSC.
And also, there's got to be something there to bind a man over on a CSC one, absolutely one with serious charges, when all could be said, some kind of mysterious object that nobody got any kind of proof other than her saying that. And that's it, nothing. There'll be some clue.
But that then becomes a question of fact for the jury, doesn't
I
it?
think it comes a question of credibility at this stage. I think it's a credibility issue that this court could rule on, that testimony was simply not credible. I've never heard any kind of testimony like that.
Okay,
And I would
but
think the court hasn't either.
there's a lot in this case I haven't heard before, but I'm just saying that I understand your argument, but what you're asking this court to do in that instance is resolve a question of fact. You're not asking me, I mean, and I don't believe that I can do that at this stage. I mean, if somebody were to find her testimony credible, then it's
Well, I'm
what it
asking,
is.
I'm asking this court to find her testimony not credible and not provable. But I even asked, did you, anybody look at the grass over there? Anybody see that she was laying next to a tree stump? Nothing, absolutely nothing.
You might have arguments regarding the investigation. You might have other arguments regarding what she said, what she is saying. But again, those are questions I think that have to be resolved by a jury. I don't believe that I can resolve it at this point.
You know, I don't want to keep saying this.
But you will.
My question is, her testimony about having some kind of mysterious object penetrate her is simply not credible. And it's not proven by any kind of physical evidence at all. And she turned down going to a sandy dip. This woman has court experience. She works for a criminal defense attorney. She's worked in the courts for a number of years. She knows what a test is, and she didn't want one. Why? Because she knows it was going to show nothing at all. And that's not what she wanted. She wanted to bury this man. Thank you, Your Honor.
I don't know that I need a response, but if you want to, go ahead.
I really want to,
Okay, go ahead and you may respond.
but I know when not to mess with this thing, Your Honor. Thank
Oh.
you. Thank you.
The court has heard the testimony in the case. There isn't a dispute as to the counts 2 through 8 and with, well, 2 through 6 to the felony counts. The court does believe as to those counts that people have sustained their burden shown by probable cause that those offenses were committed and that the defendant committed them. As to count 1, the CSC, which is the crux of the defendant's argument regarding bind over, the Ms. Kirkland's testimony. Ms. Kirkland's testimony was very clear in terms of what she experienced and what she said happened to her at that time. She relayed that to the court regarding the penetration by an object. It would seem to me that should she have really wanted to bury this defendant, she could have very easily, if she were making it up, I guess one analysis would have been to say that it was him instead of some object. She didn't do that. She relayed what she had. It doesn't really become an issue of credibility. It becomes an issue of who's going to be believed regarding it, well, whether or not she's believed, because it really isn't a counterbalancing story. So for those reasons, the court believes that that is an issue of fact that needs to be decided by the trier of fact, that being a jury. Court would also find that the people have sustained their burden as to count 1 and therefore would bind the defendant over on that charge also.
May I respond, Your Honor?
Well,
Can I approach before we address bond?
yes.
But I think we interrupted you. Was there something else before we?
Everybody's been interrupting me. So he's bound over on those counts. You acknowledge receipt of the information waiver.
I have not received it, but that can get to me. I know the charges.
Despite serious debate, the judge ultimately rules there is enough probable cause to move forward on all major charges, including the most serious count. This is a big moment. It means the case now heads toward trial, where a jury will decide what really happened. The judge essentially says, credibility disputes aren't mine to resolve right now. That's for jurors. This underscores something important. Preliminary hearings are not final verdicts. They're checkpoints. And here, the prosecution cleared the bar. So now stakes skyrocket. Trials involve deeper forensic review, cross-examinations, expert testimony, and jurors evaluating every inconsistency. And viewers, ask yourselves, after everything you've heard so far, do you think this case becomes clearer or messier at trial? Because things rarely get simpler from here.
He stays mute to those charges.
Defendant having stood mute, waiving formal reading, court will enter a not guilty plea. And yes, as to bond before I set the pretrial date.
We may approach, Your Honor.
Yes.
Thank you very much.
And I need an end date. Pretrial will be set
April 30th at 1:30 before Judge Simpson.
April 30th, 2024, 1:30. As to bond in this case, the court looks at the bond. I've heard the testimony in the case, and conceivably the bond might be appropriate, but it's well out parameters of what typically would be set. So I will reduce the defendant's bond. Currently it's set at 10 million cash surety. I will reduce it. I'll cut that in half to 5 million cash surety. Thank you.
And with that, the hearing closes on a dramatic note. The defendant's bond slashed from $10 million to $5 million, still extraordinarily high, but a recognition that pretrial detention conditions must stay within reasonable legal boundaries. Let's step back and look at the big picture. The court heard testimony involving alleged violent assault, disputed investigative steps, missing physical evidence, injury documentation, and fierce arguments over credibility. The defense hammered inconsistencies and investigative gaps. Prosecutors emphasized testimony and visible injuries. Judge Simpson ultimately ruled that enough evidence exists for a jury to hear the full case, pushing the matter toward trial, where credibility, facts, and forensic details will face deeper examination. The broader takeaway? Courtroom outcomes often hinge not just on what happened, but on what can be proven, documented, and believed. Justice systems wrestle constantly with imperfect investigations and human memory under stress. And now we turn it to you. Based on everything you've seen, where do you stand? Was this case strong enough to move forward, or should the evidence have been stronger? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.